All right, so let's go ahead and jump right into part two of our Supreme Court programming. You will remember from the last video that we ended by talking about how many different cases are requested for the Supreme Court to take a look at, and how few of those they actually ever look at. But let's go ahead and start by taking a look at answering the question of, well, what's the process that the Supreme Court needs to undertake in order to agree to look at one of those cases? Well, it's a writ of certiorari. Of course, you're all sitting at home being like, of course, Mr. Biggs, we knew that that was a writ of certiorari, right? You're all saying that in this very moment. But just for those of you in the audience that don't know what a writ of certiorari is, a writ of certiorari is sort of the formal term for the Supreme Court's kind of like official approval of whether or not they're going to hear a case that comes from one of the lower courts. And also, what the writ of certiorari does is, as you can see here, where's my little pointer? Here we go. Is it forces the lower court to send all the information about the case. So more formally, this writ of certiorari is like the thing the Supreme Court needs to do in order to agree to hear the case. But really, what this writ itself does is basically says, hey, lower court, send us all the stuff from the case when you decided so that we can see what your decision was and see what you based that decision on so that when we decide, we already have a pretty good idea of how to argue it. And in order for them to do this, in order for them to do this writ of certiorari, 9 of the justices have to agree to hear the case, which, as you'll remember, since there are 9 justices, is less than half, but there still needs to be at least 4. And so the Supreme Court will only grant one of these writ of certiorari's when there are pretty special or important reasons to do so. As you'll remember from previously when we took a look at the fact that they only hear like 100 out of the 10,000 case requests that they hear, there has to be pretty important reasons. So first, there has to be an issue of controversy that was decided differently by the courts. So generally, they'll agree to take a case if, like, a district court decided one way and the appeals court decided a different way, or if the appeals court couldn't decide how to figure it out. But there has to be some confusion about what the decision is, or the controversy itself must reflect a new development in technology. So it has to be a thing that maybe the judges at the previous court levels weren't yet ready to think about or decide, and that there weren't any laws for. So, of course, if you guys remember Napster, like in the early 90s, which was like the first program that was used to download music online, the issue of Napster and whether that was like theft of music went directly to the Supreme Court because nobody had ever dealt with an issue like that before. So sometimes the Supreme Court will take an issue if it is something that has never been dealt with wise, technology or culture-wise. Or the Supreme Court, lastly, will take issues if they are related to like culture, like changes in the way that a culture or society views things. So you'll remember the same-sex marriage stuff pretty recently went to the Supreme Court. You'll remember Brown v. Board of Education, which like desegregated schools. Hopefully you learned about that in American Studies. Civil rights stuff also will go to the Supreme Court. So why wouldn't they take a case? Well, A, if they just plain agree with the lower court, there's no reason for them to spend a lot of time talking about it. Also, sometimes if an issue is too controversial, they will just decide not to take the case so that they aren't in charge of making the decision. In the previous video, you'll remember that I had mentioned that when the Supreme Court makes a choice, their decision becomes almost like law. Well, sometimes the Supreme Court would rather just let people vote on making laws instead of having like the 9 of them just choose what the official ruling will be. So like human cloning, there have been times in which they've talked about bringing human cloning to the Supreme Court, but the Supreme Court's like, nah, man, we should make laws about that and people should vote on it. Also, the Supreme Court will refuse to take a case if they have already made a ruling on an issue like that before. They'll basically just say, hey, we already told you what happens in this situation. Use that previous decision. And then they just don't need to look at it. Also, sometimes they'll get requests by people to have them hear a case when it doesn't even affect them. And so they will only ever take cases if the people trying to bring the case to the court are directly affected by them. And also, sometimes they'll just deny cases if the issue itself is like a state issue and not a national issue. Like if they're talking about, I don't care, legalization of drug stuff. As we noticed when we dealt with federalism a little earlier, we know that that's a state issue. And so they'll just let the states figure that out. They'll say, you know what, we're not going to make a national ruling about this particular issue. We're going to leave it at the states. So how does the Supreme Court operate? Well, they are only in session for part of the year. And generally, that's like the same part of the year that you guys are in session. They take summers off, basically, is what I'm trying to say here. So they're not in session all of the time. And they generally only hear cases Monday through Thursday. So they are, I wouldn't say that they're off the rest of the days. Usually on like Fridays, what they're doing is like office type organizational stuff, kind of taking a look at what cases there are, planning what cases they'll hear. But they're only ever really in the Supreme Court Monday through Thursday when they're in session. And so just to give a little bit of an explanation of what the court looks like in the Supreme Court, meaning like what a case would look like, we'll go over that a little bit because it's totally different from the way that you generally see it on TV. So before the case, the justices read both sides' attorneys' overviews. So there are no attorneys, the people don't show up, they just get the documents from the previous cases, and the attorneys will send the Supreme Court new stuff to read, and they'll just read it. They don't have anybody there really telling them stuff from their attorneys. There are no witnesses, there's no jury. After they've had the chance to read this stuff, they do have the attorneys go ahead and give a really quick overview testimony, and they only have 30 minutes to do it. So in normal cases like you'll see in TV, the attorneys can go on and explain whatever, and they try to convince the juries. Here, they just give them a thing to read, then the attorneys give a 30-minute overview, and that's it. No witnesses, no jury, just the judges, just the attorneys, and their documents and their quick statements. Although, at any point, the justices do have the ability to interrupt the attorneys in their 30 minutes to ask any sort of questions. But what sort of is a bummer for the attorneys here is that anytime there is a stop for questions, that is still counted within their 30 minutes. So if like one of the judges decides to ask like a 5-minute question, well then they really only have 25 more minutes to talk, right? So there that is. Afterwards, and after the justices have heard all of what they feel like they need to hear for the case, they will then announce their official decision, which is known as an opinion. So if ever you're hearing about Supreme Court stuff and you hear that about the justice's opinion, in this case, opinion sort of seems like, oh, well, here's how we feel about it, right? Like sort of just kind of a not really based in fact kind of thing is generally the way we think about it. But when it comes to the Supreme Court, their opinion is actually the word that is used for their decision. And each justice records an opinion. And there are a few different types of opinions that come out of each case. There is the majority opinion. There is, and one of the justices will write it. A justice, which, and in this case, the majority opinion, of course, is the decision made by most, right? Made by the majority. So generally speaking, the majority opinion is the official result of the case. This is the thing that becomes the official decision. But a judge that disagrees with that opinion, so if it's not like unanimous, if all judges didn't agree, one of the disagreeing ones will write a dissenting opinion. And this is just their ability to explain why it is that they disagree with whatever that decision was. But also, sometimes a judge will write what we call a concurring opinion. And this opinion is basically saying, hey man, we agree that the result is of the majority opinion is right. We agree in the result, but we do not agree for the same reason. Here's why we think that this was the way a court case should have been argued. So, of course, sometimes there is a unanimous opinion. Sometimes all justices agree. About a third of the cases actually end up being unanimous decisions, which is really a pretty big deal. Getting anything to be unanimous ever is pretty nutty. So it's pretty cool that about a third of them end up being unanimous. Once again, there's the majority opinion, which is the most. This serves as the final decision, essentially becomes law. There's also the dissenting opinion. This is sometimes also known as the minority opinion because this is the opinion of those that dissent, that disagree, right? And this is doesn't really have any legal bearing. It's mostly just a chance for the people that disagree to be able to say, hey, we disagree. We don't think justice was served. Here's why. Sometimes the dissenting opinions are cool because later on, if like culture or society changes their view on a thing, they can go back and look at the dissenting opinion because there will be then some sort of legal basis for a different opinion on the issue. And then once again, there's the concurring opinion, which they basically agree with the result of the majority opinion. They agree that justice was served, but they disagree with its reason and have a different reason. And once again, this is mostly just an opinion, doesn't really have a legal basis. But sometimes later on, if similar issues come up in the future, just like with the dissenting opinion, they can look at this one to have a little bit of an idea of how the Supreme Court thought about stuff from a little bit different of a perspective. And then lastly, I just wanted to take a little bit of a chance to talk about what limits there are for the power of the Supreme Court. First, there's the checks and balances issue that there's just a lack of enforcement power. Sure, the Supreme Court has the ability to make decisions, right, and decide what the correct course of action is, but they don't have their own police force. They don't have people to go through and actually make sure that happens. The executive branch does that. So if the executive branch simply doesn't do a good job of enforcing the ruling, then their decision really doesn't matter that much. But also there's congressional influence, and that happens in a few ways. So first, Congress is the one that ultimately approves justices that are appointed by the president. So justices only ever manage to get into the Supreme Court by having the president choose them, and then Congress has to agree to allow to give them the job. So Congress has the ability to be like, nope, and then if they disagree with like the politics of a particular justice or potential justice, and then they can just not get the job. Also, Congress has the ability to remove judges based on misconduct or incompetence. They can be impeached. They can be removed from office if Congress decides that they are, not doing their job. And this, of course, since Congress sort of represents the people, allows people to, vote for them, and they represent people more directly. This allows people themselves, like citizens, to be able to feel like they are regulating the Supreme Court as well. But also, Congress can amend the Constitution and basically go around the Supreme Court's decision. So, like, if the Supreme Court makes a particular decision on something, like pretty recently the Supreme Court decided that same-sex marriage should be legal. If later on the people of the United States disagree with that statement, they feel like they don't want to allow that, then theoretically they could help pressure Congress to make an amendment which would make a law going against, what the Supreme Court decided. So that's also a possible action that they have the ability to do. But also there are a certain amount of legal and customary restraints. So like a court obviously cannot reach out and take cases. They are limited by the fact that they do not have original jurisdiction on most types of cases, right? They can only ever hear cases that come to them. The Supreme Court can't just reach out and decide, you know what? Let's talk about freedom of speech stuff today. Let's change some things about that. They can't really do that. They don't have the ability to reach out and make choices. The issues have to come to them, and they can only handle issues that are brought to them by other people. But also, if there was a previous case on the same issue that was decided before, they have to follow what had been decided by previous cases. They can't just take, another same-sex marriage issue and then make a different choice. That's it for that. The Supreme Court already made their choice. So they don't really have the ability to just decide freely how to, change the way that we look at, controversial issues. But also, they are totally bound by the Constitution, and there are a number of things in place to make it so that the Supreme Court justices are not beholden to their political opinions. In fact, if people find that they are being too political and they're basing their decisions not on the Constitution, but instead on their political opinions, they could be in danger of being impeached. So in that way, they don't have a lot of freedom of choice. They simply have the freedom to defend the Constitution. And all right, so that's it for part 2 of your introduction to the Supreme Court. And hopefully in your exploration of your IKTO issues, we'll have some opportunity to explore a little bit more of these things a little bit more deeply. But that's it for now.